201572. What's been noticed for today is Mr. Brooks' motion to vacate judgment based on fraud on the court, which was filed on March 10th, 2023. The court has reviewed the motion in addition to mother's response to father's motion to vacate. The court notes that it entered an order yesterday denying motion to disqualify. The court entered already this morning before it took the bench an order denying motion to change venue. Announce your presence.
Good morning, Your Honor. Amelia Lynn Morshell on behalf of the petitioner Shakia Floyd.
Shakia Floyd. Good morning. And I have Mr. Sobers.
Good morning, Sobers Brooks.
Good morning. So let me first hear from Mr. Brooks. I've reviewed the motion and the response. Please make yourself comfortable.
Yeah, sure.
You have to stand, whatever you prefer.
Fine. Okay. As a pro se, I'm fully aware that the court should be enforcing laws in an impartial manner. Nonetheless, the opposition have not proven or shown any type of arguments that to omit Delaware's state tax, Wilmington city tax, monetary retirements, salary reduction has been constitutional. They have neither provided an argument to oppose Florida Statute 61.30. Nonetheless, I've been getting disqualification here, dismissal here, but there have been no arguments to substantiate why Florida Statute 61.30 plays no role in this case. And why is it that to omit information have now become constitutional? That's all I have.
Thank you, Your Honor. With respect to this particular motion, the court will remember that there were two. This motion seeks to vacate a judgment that is over 4 years old. The original judgment entered on June 11th, 2019, after a full hearing in which, in Mr. Brooks's motion, he acknowledges that he provided evidence and raised issues relative to the calculation of child support to Judge Bornstein, who was hearing the case. After that judgment entered on June 19th, Mr. Brooks did not file any type of motion seeking that there be a set aside, that it be vacated, or that there be an appeal until September of 2019. At that point, he filed what was titled a motion for rehearing appeal, even though he was beyond the 15-day time period for a rehearing, and he was beyond the 30-day time period for an appeal. That went to hearing in October of 2019. That motion was denied. Thereafter, my client filed her underlying petition for modification, as well as a motion to enforce and compel compliance with the judgment with respect to the provisions related to child support, as Mr. Brooks stopped paying his $1,100 a month obligation in October of 2020. My client waited almost 2 years before she took any action to try and enforce that judgment. After my client filed her petition in March, he filed the instant motion that's before you today, alleging that there was fraud upon the court and that he was entitled to bring this motion because of the fact that the fraud section of statutes grants more than a year time period to be able to bring that motion. The statute and the case laws that reflected in the response are clear that there's two different types of fraud. If it were extrinsic fraud, then yes, you have more than a year time period to bring it before the court. Extrinsic fraud is defined as preventing somebody from participating in the proceedings and behaving in a manner that prevents them from basically being able to avail themselves of the court in any way. That's not the case here. Mr. Brooks was present at all of the hearings. He was present at the hearing when the case went to final judgment in 2019. He tried to avail himself of the court thereafter, although not in a timely fashion, to seek relief from the judgment. The client hasn't done anything to prevent him from doing that. As far as intrinsic fraud, which he also may seem to be arguing, but it's not clear based upon his motion, even if he's filing under that and saying that there was some misrepresentation or what have you, he only had a year to bring that motion. He didn't bring it until almost 2.5 years beyond the time period that he was able to do so. As such, the court can't grant his motion to vacate. We're dealing with a situation where child support was calculated after a full hearing in which both parties had the opportunity to present evidence. He's been saddled with, or he's been ordered to pay an amount that he does not want to pay. And the fact is, he hasn't paid it for the last 2.5, almost 3 years. So the fact that he doesn't like the order doesn't mean that he's still not obligated under it. He's failed, he was unsuccessful in prior attempts to either vacate or get other relief from this order, and this is a last-ditch effort. And as you can tell by the motion to recuse that was filed, as well as the motion to change venue, this really is a situation where everything is being thrown against the wall to see what sticks. The reality is, the order is valid, and he has been out of time for 3 years to try and contest it. Thank you, Your Honor.
Let me hear from Mr. Ford.
Okay, once again, we go back to the same thing again. Never heard a word said about Florida Statute 61.30. That's not my law. That's a law that is the governing law for child support. Florida Statute 61.30, the attorney never mentioned it. Neither did she mention the omission. She stated about intrinsic and extrinsic fraud. That was never included in any of my motion to vacate. It said based on fraud on the court, which is a total different topic. Fraud on the court by an officer of the court gives you unlimited statute of limitation based on Rule 60. These aren't rules that I'm bringing up. These are rules that are in existence. The attorney is sitting beside me is total disregarding all the rules. She do not understand that you cannot abridge rules. She's saying that I'm at a last-ditch effort. Last-ditch effort for what? When rules are broken, it's up to the court to impartially enforce actions against those violations. She filed a document knowing very well, as Exhibit A, that document excluded information. That's a violation of Florida Statute 83.13. There's no rule that Ms. Washoe is bringing into her argument. You cannot she can't bring the rules for herself. Rules are there. She have to make mention of those rules and show me why my argument don't have no stand, right? I'm talking about the rules, but she's not coming up against the rule. If you're going to counter me, counter the rules. Don't counter me directly. Counter the rules. I've not heard you counter a rule as yet. I've not heard you said, okay, well, those items were legitimately excluded. I've not heard you said, oh, well, Florida Statute said, yes, they can be excluded. Those are the arguments that I want to hear. If I hear those arguments, I wouldn't have been trying to do anything else. I have no problem for child support. My dad took care of me all along. I have no problem to pay child support. Shakir Floyd knows that. I have no problem to pay child support. The fact of the matter is this, that I have a problem if someone's going to violate my rights.
Anything else?
Oh, no, sorry. No, that's all, sorry.